Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Hello, everyone. So I decided to take a little break from doing some work and trying to see what I can update you guys on. So if you have been following me, then you kind of know what's going on in regards to the independent journalist Sarah Fields. She filed a lawsuit against Charleston White, Tiffney Billions, and Drew Anthony, who is Carmelo Anthony's father. Charleston White had a default judgment rendered against him because he failed to respond to the lawsuit. So that's normal procedure. The next part of that, he pretty much has to, well, not him, but Sarah would have to prove up her damages in order to be awarded a judgment. So that is that part. But I wanted to bring you guys here today to let you know that Tiffany Billions just got hit with a response opposing her motion to dismiss Sarah Fields' lawsuit. And this particular filing makes a pretty aggressive argument, one that her motion to dismiss is 125 days late, that discovery defaults have already sealed her fate on the merits, and that the court should make her pay plaintiff's attorney fees for it. Let's break down what's actually being argued here. I'm Cassandra, aka your favorite paralegal, and this is Legal Doc Talk. So, y'all know me, I am a sucker for court cases. So this is the, how many pages? I believe it's 11 pages that her attorney, Sarah Fields' attorney, filed in response to Tiffany trying to dismiss that lawsuit. So if you want a copy of it, let me know. But otherwise, I'm going to just kind of break everything down, summarize everything so you guys don't have to read through it. So a quick primer, because this only makes sense with this particular background. So, the Texas Citizens Participation Act, also known as the TCPA, is a Texas anti SLAPP law. It lets defendants get lawsuits dismissed early if the claims target their exercise of free speech and the plaintiff can't back up the claims with clear and specific evidence. It's meant to be fast, kind of like a screening tool used at the very beginning of the case, not a mid litigation weapon. That fast part is baked into the statute itself. A TCPA motion has to be filed within 60 days of being served with a lawsuit. That deadline there, it's mandatory. That deadline is mandatory. So here's the actual sequence according to the filing. November 25th, 2025, Sarah Fields filed suit against McAdoo, aka Tiffany Billions, Charleston White, and Drew Anthony. January 13th, 2026, McAdoo, aka Tiffany Billions, is served. That there starts her 60-day clock. February 11th, instead of moving to dismiss, McAdoo asked the court for permission to file a late answer and starts litigating the case on the merits. February 24th, co-defendant Drew Anthony appeals the denial of his own separate TCPA motion. That triggers an automatic stay of the trial court proceedings under Section 51.014, paragraph B. March 14th, Tiffany, her own 60-day deadline passed. She didn't file anything. May 13th, the plaintiff, Sarah Fields, serves the request for admissions. I wonder why not discovery. Oh my gosh. And just me, kind of, and I'm just thinking out loud, like when we file suits and disclosure period has passed and I'm drafting these requests, I'm hitting you with a request for admissions, a request for interrogatories, or I would say a first set of interrogatories and then a request for production. But I can't tell anybody how to do their thing. June 12th, the deadline to respond to the request for admissions passed. Tiffany did not answer them. June 30th, the appeal court ruled on Anthony's case, and so the stay actually lift. Okay, so then that means that the trial court can proceed with litigation. June 17th, uh, McAdoo, aka Tiffany Billions, she files her TCPA motion. That is 125 days after her own deadline expired and more than 8 months after the lawsuit begins. Okay, so hopefully y'all get the timeline and y'all could see. In Texas, we don't play about deadlines. You miss a deadline, that there alone can, it's not going to work in your favor. I'm just going to be honest with you. All right, so the argument that Sarah's attorney makes is that the motion is just late. The response first and simplest argument is the untimely of the motion on its face, and Texas court treats that as grounds for denial without even reaching the merits. Tiffany's counterargument is that Anthony's inculpatory appeal stayed the whole case, including her on deadline. The response pushes back hard on this, citing a Texas Supreme Court case called In Read of Geomet Recycling. The core idea, when the statute says stays all other proceeding in the trial court, the legislator was protecting the party who actually took the appeal from having to keep litigating while that appeal is pending. It is a shield for the appealing party, not a blanket pause button that extends every co defendant independent deadlines. And there's a sharper point buried in here. Tiffany had already let 42 of her 60 days run before the stay even started. She wasn't diligently preparing a TCPA motion during that window. She was busy asking for permission to file a late answer instead. The response argues you can't let your own deadline lapse through inaction and then blame a stay you weren't actually relying on at the time. There's also a policy argument here mentioning if one co-defendant's appeal could silently extend everyone else's deadlines, defendants in multi-party cases could theoretically string out TCPA motions indefinitely, each one riding a previous defendant's appeal. The response argues that that's exactly the kind of delay tactic the TCPA 60-day rule exists to actually prevent. All right. Here's the part I think is actually the bigger problem for Tiffany, regardless of how the timeless fight goes. She was served. She was served the request for admissions on May 13th. Under Texas Rule of Civil Procedure 198.C, paragraph C, 198.2, paragraph C, if you don't respond to requests for admissions in time, they're automatically deemed admitted and no court order is required. Tiffany never responded, and according to this filing, she never even moved to withdraw those deemed admissions. Now, I don't know if she didn't have an attorney at that time, but I'm telling you now, when you get into a lawsuit, that's when, as soon as that, you know, petition is filed, and the defendant or the respondent it serves, that's when the clock starts ticking. There's a whole bunch of deadlines. And as a paralegal, like, we have to ensure that we utilize the calendars in a case management system so we know not to miss any deadline, because that request for admissions, interrogatories, disclosures, request for production, that is all part of discovery. So it's like discoveries handled, depositions handled, and then mediation. If it doesn't work out at mediation, then the next thing is trial. in civil litigation here. All right. But going back to this, so what's now conclusively established against her? According to the response, that she published the specific statements at issue, that she had no firsthand evidence, no official record, and no named source for what she published, that she got a demand letter telling her the statements was false and kept publishing anyway, and that she made or facilitated a false report that sent officers to plaintiff's home, plus a report to Child Protective Services. Why does that matter so much? Because those admissions don't just support plaintiff's claims. The response argues they actively defeat Tiffany's own defenses. Her substantial truth defense can't survive an admission that she had no firsthand evidence. Her no actual malice defense can't survive an admission that she published without any basis or kept going after being told it was false in writing. Then there's a third independent argument. Even setting timelessness and the admissions aside, the response argues the TCPA simply doesn't apply to several of the claims at all. Specifically, the false report that triggered an armed police response, the CPS report, and publishing a minor child's name alongside images of plaintiff's home. The argument is straightforward. TCPA protects the exercise of free speech on matters of public concern. Calling in a false report to send officers to someone's house or making a false report to child welfare agency isn't speech, it's conduct. Under this argument, the statute was never designed to shield that kind of behavior just because it happened alongside public commentary. Okay, everybody got that? Now, last part. The response asked the court to award plaintiff her attorney's fees under Section 27.009B, which allows fee shifting if a TCPA motion is found frivolous or filed solely to delay. The filing points specifically to public statements attributed to Tiffany about wanting to drag the litigation out, arguing that the motion filed 125 days late after already litigating the merits and defaulting on discovery fits that description. So it's important to say everything I just walked through is, Sarah's characterization filed in opposition to what Tiffany filed in her motion to dismiss. Tiffany's own declaration disputes several of these points directly, including disputing that she made certain statements at all, and asserting a substantial truth defense tied to a claim that the courthouse insider leaked information to plaintiff. The response argues that theory doesn't hold up factually based on the timing of the post Tiffany cites as evidence. But no court has ruled on any of this yet. This is just one side's brief, it's not a decision. So I, Cassandra Lynn, is going to be watching for the ruling on this one, whether the court denies on a timelessness alone or goes further into the merits given how strong the discovery default argument looks. Follow so you can watch out for this, okay? Make sure that you are subscribed to my channel so if I do any of the videos and upload or if I go live, you get the notification. And please like and share. Again, I'm Cassandra, aka your favorite paralegal, and this is a Legal Doc Talk. Bye.